Mr Speaker.
Scott Simpson.
Thank you, Mr Speaker. It's a pleasure to stand and take a call on the second reading of this Health Protection Amendment Bill. And just following on from the last speaker, Larissa Wall, I think that for many on the committee, the biggest education was actually not ionising and non-ionising, but to actually separate it from iodising. At one stage, we had someone who was convinced that it was iodised, as in salt, and of course it's a completely different thing. Sir, I'd like to join with other speakers tonight in congratulating the work of the total committee, actually, when we see a select committee working at its collegial best to ensure good outcomes for legislation. I think that that's when we see Parliament working at its best. And under the chairmanship of my colleague Simon O'Connor, I'm delighted to report to the House that in fact the committee is functioning very well, very collegially, and we're getting good results. And I think you've seen members will have seen something of the tone of the committee reflected in the speeches that we've heard tonight, and I'm sure that that will continue to be the case as this debate continues through. So, notwithstanding the minority report from the Labour Party, New Zealand First and the Green Party, I'm very pleased to learn that I think all those parties are going to support the progress of this bill through the House. The point of difference between the government members and opposition members around the committee stems, as Larissa Wall has said, about the extension or the potential extension of the commercial UV tanning clinics, and that's a step, as the committee chair Simon O'Connor made clear during his contribution, and also the minister, that we think on this side is at this stage a step too far. And I'm personally quite relaxed about that at this stage, but I would like to, I guess, reserve my personal view on how that might unfold over the years to come. Because I think that in many of these matters relating to health and science and education, we find that it's a learning process, that technology and information changes, and that we find ourselves in a position to be flexible and nimble of foot in terms of the legislative response. So this bill seeks really to amend the Health Act of 1956. And the fact that we are amending the Health Act of 1956 gives some context to the change that has occurred in both medical science and in human knowledge over the period of time since the Principal Act was passed by this House. And so it's very appropriate, given the changes in both medicine and also in society, that we update legislation to accommodate changed circumstances. Back in 1956, sir, I doubt that there could have conceivably been a situation that may exist today where people, for reasons that were probably almost criminally motivated, would use the fact that they had some kind of communicable disease, some kind of infectious disease, to actually reap harm upon other human beings. I think that back in 1956 that would have been something that we would have all found difficult, or the legislators back in 1956 would have found difficult to comprehend. Regrettably, we have had cases in our recent history where there have been, for instance, those that have been, and this is very rare, I know, but it's important as a legislature that we accommodate the rare situations where people infected with AIDS, with HIV, have gone about actually infecting others in a way that is, as I say, criminally negligent and culpable, if not anything to do with the medical responsibility. So we need to update our legislation to ensure that as a society we have an opportunity to protect the greater good of the wider community from what are essentially rogue individuals. And this bill, this amendment bill, essentially does that. It creates a progressive stage of restrictions, management if you like, or controls might be another word that we might like to use, in terms of managing people who have a defined range of infectious diseases. Some of those diseases are quite damaging and they are highly infectious, and I think that we have an obligation, an absolute obligation as legislators, to put at first the protection of the wider community. And there are times, sir, when occasionally we have to think about the potential impact for the rights of individuals versus the rights of the greater, wider community. And this bill, I think, seeks to achieve that through a number of means. One of the I guess, constitutional issues that those who are interested in matters relating to civil rights and personal human rights might have been concerned about, and it was raised in Select Committee, was how far would these additional management provisions go in terms of inhibiting the rights of individuals who may be infected with a particular disease. And so the framework that the committee and this legislation seeks to adopt uses a principle of risk management and proportionality based on the risk associated with the individual versus the risk associated to the wider community. And I think the bill places as few restrictions as are possible, while at the same time maintaining that greater good concept and principle that is important to protecting the wider public health objectives of the original statute and, of course, this amending piece of legislation. So the measures provide actually better tools for public health staff to deal with people who, for one reason or another, do not voluntarily seek treatment or do not voluntarily modify their behaviour once they've been diagnosed with a communicable and notifiable disease. And so that behaviour, I think, is one that we need to balance carefully against the individual's rights. So where consent is not given, and I stress that this is a very small minority of potential cases, the current legislation simply doesn't allow for an appropriate response. For instance, the current legislation, Mr. Speaker, doesn't allow for the detention of an infected person. The provisions in the bill covers the rights and duties and offences and penalties and a range of restrictive powers and procedures for directions and court orders, and it also creates a regime for urgent orders for people whose behaviour, consistent and persistent behaviour, may place others at risk. And I think that's an appropriate, moderate response given the state of society and science that we have today. Powers at the lesser end of that regime, for example, the power to give directions, are able to be exercised by a medical officer of health. And I think that, again, provides an appropriate response to the lesser communicable and infectious diseases. Directions are the community level measures, and they may include, for instance, directing people to seek testing or treatment, or the counselling, or they may involve the direction of people not to attend public places for a specified period of time. And there would be some who would argue that the restriction on the movement of an individual may be a step too far. I'm not one of those people, sir. I think that actually this is a balance that is about right. And if people choose not to take their responsibilities to their wider community seriously, then I think we as a society have an obligation to enforce those responsibilities for them. So the lack of such intermediate powers has been identified as a weakness in the 1956 legislation, and so this amending bill that we're considering here tonight provides a more restrictive power, for example, detention in some cases, but that can only be exercised following a public health order made by a district court. The Select Committee considered appeals and the process all around that sort of thing, and I think we've landed in a pretty good spot. So, sir, I've addressed most of my comments this evening on the second reading to matters relating to civil rights, the ability of the state and us as a legislature to enforce powers on individuals in cases when that is required, and I think balanced and necessary. This, sir, I think is a very good piece of legislation. It updates some now quite old legislation that was well intentioned in 1956 but is in serious need of an update. This bill does that, and I thoroughly commend it to the House, and once again thank the Select Committee for the collegial and congenial way they have conducted their affairs. Thank you, Mr. Speaker.